seated.
If I can just explain more my objection, or maybe it's an objection to lack of foundation.
So you want to
Can I-
make more of a foundation?
Well, I don't even know.
That's an easy objection.
And that's, I'm just confused, Your Honor. And the reason is, my understanding was that Opinion 7, Officer Schur's use of deadly force against Mr. Leoy was unreasonable, excessive, and contrary to generally accepted police practices because he supposedly didn't know that there was a second, he did know the second discharge had been fired, and therefore he wasn't in fear of great bodily harm or death, and therefore was unreasonable. And he hasn't gone through that. He's just saying, well, do you think in general that this was excessive? But the report talks about why he thinks it's excessive.
I think the question was, would a similarly situated officer have made the same decision?
But he hasn't talked about what the situation is yet. I understand that Mr. Bloomfield's going to testify about this opinion.
So then you just wanted to talk more about the
It's
situation?
well, Mark, which expert is going to talk about this situation? Because he suggested that Mr. Bloomfield is going to talk about the ones involving the taser, and this one does. And then Mr. Stoughton is going to talk about, I think, the foot chase and the failure to give a warning.
Sure. We can't say Officer Schurr did this. We've talked this over and over, that a reasonable officer similarly situated, in his opinion, number 7, Officer
If you
Schurr.
direct me to the page, so I can.
This is
use
page
it.
63, 63 of this report. Officer Schur's use of deadly force against Mr. Loyola was unreasonable, excessive, and contrary to generally accepted police practices. So that's essentially what I asked him, except I can't say Officer Schurr, I have to say a reasonable officer similarly situated.
I agree with that.
And if you let me finish.
I'm sorry, Mr. Becker.
I can, just because I'm starting out with that, and then I can say, can you explain why that is? He won't let me do that because, I don't have to do my direct based on what he'd like to hear first.
I agree, Your Honor.
Oh.
I'm sorry, but I thought Mr. Bloomfield was testifying about that.
Okay,
Because
so
this
we
is
can have
based on
jurors-
tasers.
Right, but you
And-
didn't ask him about a taser.
He's about to.
Well, you didn't, so you're objecting about something that hasn't happened. It's like, I don't know how I'm supposed to rule on.
Well, because he's
something
gonna
that
give his ultimate opinion about the taser before we've established that he's a taser
He
expert.
hasn't asked him anything about it.
It's still part of his opinion, I cannot go into the decision, it's one of the things, but I don't have to get into his details of a taser. That's part of the whole thing, he's been testifying about the totality of the circumstances.
But you're okay with that question? You can answer that. The
Assuming
question that
that-
you objected to.
Yeah, I assume he's gonna go into the opinion number 7 then.
Is he going to go into opinion number?
That's
seven?
part of his opinion. Now, I'm not going into details with him, but that's part of the things, the basis, he did it jointly with Nick, and so they can say, okay, but Nick is gonna testify to that.
Okay, so we don't have the jurors come back in, that was a short break for them.
What should I be able to voir dire Professor Stoughton on whether or not he's a taser expert, because that's the basis of this opinion.
If he asks him a question that requires a response from a taser expert, then yes.
Okay.
But that question that he just asked, I don't believe does that.